Hey everyone, and welcome to The Explainer. I am absolutely thrilled to have you with us today because honestly, we're tackling one of the most fascinating, debated, and frankly, complex issues in India's public policy and constitutional law. Whether you're a competitive exam aspirant, a law student, or really just someone wanting to understand how affirmative action is evolving, you are in exactly the right place. We're going to break down a massive legal paradigm shift that just happened in 2024. Okay, let's dive into this. The creamy layer debate in scheduled castes and scheduled tribes reservations. Here is a quick roadmap for the explainer so you know exactly how we're breaking down this dense legal shift. Number 1, defining the creamy layer. 2, the 2024 landmark judgment. 3, the constitutional debate. 4, important legal precedents. And 5, key takeaways. All right, section 1, defining the creamy layer. Let's get our legal baseline established before we look at the recent disruption. So this question right here, this is the engine driving the whole debate. At the very heart of India's reservation policy is this pursuit of equality, right? But the core constitutional question we are facing today is simply this. Should reservation benefits be distributed differently within the exact same community? In other words, if certain groups inside a designated category are vastly more disadvantaged than others, shouldn't the system be adjusted so the benefits reach the people who need them the absolute most? Well, to tackle that question of equitable distribution, the legal system came up with the creamy layer principle. It's kind of exactly what it sounds like, skimming the cream right off the top of the milk. It's a legal doctrine designed to exclude the relatively advanced members of a backward class from reservation benefits. The logic is actually pretty straightforward. By removing those who have already achieved a certain level of social and economic advancement, which the government identifies through things like income or parental employment, the remaining benefits can flow directly to the most marginalized sections of that very same community. This whole idea actually originated back in 1992 in the famous Indra Sawhney case. To put that into perspective and see how it works right now, following that 1992 judgment, the Supreme Court upheld a 27% reservation for other backward classes, or OBCs, in central government services. But they attached a crucial condition to it. The creamy layer principle absolutely must be applied to this 27% slice. So for OBC reservations, this principle is fully active today. The more advanced members are excluded to ensure they don't monopolize the benefits. But here is where the distinction becomes incredibly important for us. While the creamy layer applies across the board for OBCs, its application to scheduled castes and scheduled tribes has historically been completely different. Right now, for SCs and STs, this principle is limited strictly to promotion quotas, and that rule comes from the 2018 Jarnail Singh judgment. So, just to be crystal clear, as of today, there is no law, no binding Supreme Court mandate that extends the creamy layer principle to SC and ST reservations as a whole. It doesn't apply to general direct recruitment, it's only for promotions. Section 2, the 2024 landmark judgment. If those rules were seemingly settled, what exactly just changed? Now, what's really interesting about this slide is that overwhelming ratio. In the 2024 case of State of Punjab v. Davinder Singh, the Supreme Court delivered an absolute blockbuster of a constitutional judgment. We are not talking about a narrow, highly contested split here. This was a decisive 6-1 majority. And a ruling with that kind of weight completely reshapes how we understand the administration of social justice in India moving forward. So what did this 6-1 majority actually decide? The core holding is that states now legitimately have the constitutional power to create subclassifications within the SC and ST lists. To do this, the court had to explicitly overrule a 2004 case called EV Chinnaiah, which basically assumed that SCs and STs were these universally homogeneous groups that simply couldn't be divided. The 2024 court said no, absolutely not. These lists contain diverse communities with vastly different levels of representation. By allowing subclassification, the court is aiming for substantive equality, basically recognizing that formal equality on paper just isn't enough if some communities are still lagging way behind. But there's a vital safeguard built in here. States can't just subclassify arbitrarily or for political gain. They absolutely must have empirical, quantifiable data proving that specific subgroups haven't benefited equally. Okay, listen closely to this next point, because this is literally where so much of the public confusion is coming from. During this 2024 judgment, 4 of the judges wrote separate opinions observing that the creamy layer principle could perhaps be considered more broadly for SCs and STs, way beyond just promotions. However, and this is a massive distinction, these were just observations. They do not form the binding ratio of the judgment. The Supreme Court did not legally mandate or direct the general application of the creamy layer to SC and ST reservations. It was a suggestion, a provocation for future policy, sure, but definitely not a binding new law. Section 3. The constitutional debate. Those observations we just talked about have sparked an intense national conversation. The tension between these two perspectives is just profound. Supporters of applying the creamy layer broadly argue that it's frankly the only way to achieve intra-group equity. They point out that over the decades, some subgroups have benefited vastly more than others. By excluding the advanced members, we can finally target the most intensely disadvantaged people within those communities. On the flip side, though, critics point out a very real, fundamental sociological point. Caste and class are not the same thing. They highlight that simply gaining economic wealth or mobility does not magically erase historic caste discrimination. An economically successful SC or ST individual might still face intense social exclusion, stigma, and prejudice in their daily life. And this brilliantly illustrates how both sides are looking at the exact same constitutional objective, but they are weighing the priorities completely differently. Supporters are primarily focused on economic advancement and ensuring a fair, highly targeted distribution of benefits. They view it as just a logical extension of that 2018 Jarnail Singh ruling. Critics, however, are primarily focused on historical isolation, especially for scheduled tribes, untouchability for scheduled castes, and the absolute need for adequate representation in public life. They argue that reservations weren't just built as a poverty alleviation program to cure economic deprivation, but to guarantee experienced representation for historically oppressed communities. Section 4. Important legal precedents. Let's move to and see how this builds historically. Let's move to and see how this builds through the years. Think of this timeline as your cheat sheet for the evolution of this entire policy. It all kicks off in 1992 with Indra Sawhney, which locked in that 27% OBC reservation and birthed the creamy layer principle. Fast forward a bit to 2004, and Chinnaiah established the rule that SCs and STs were a completely homogeneous class, which banned subclassification entirely. Then, in 2006, Nagaraj upheld reservations and promotions, but strictly required quantifiable data on backwardness and representation. Following that, the 2018 Jarnail Singh case modified Nagaraj. It essentially said, okay, you don't need data on backwardness anymore, but crucially, it applied the creamy layer specifically to SC and ST promotion quotas. And finally, we arrive at 2024. Davinder Singh officially overrules that 2004 homogeneous rule, unlocking subclassification based on empirical data. You can visibly track how the court's stance has evolved over 3 decades to allow for much more nuanced targeting of these benefits. Of course, all of those Supreme Court judgments don't exist in a vacuum. They are anchored directly in the Constitution itself. Articles 15.4 and 16.4 are the bedrock here, empowering the state to make special provisions and public employment reservations for backward classes, SCs, and STs. But Articles 341 and 342 are just as vital to understand. They explicitly state that the president identifies and specifies the scheduled castes and tribes, and only Parliament has the power to add or remove communities from those master lists. The 2024 Supreme Court was incredibly careful to note that while states can subclassify to distribute benefits better, they absolutely cannot alter the presidential lists themselves. Section 5. Key takeaways. Let's consolidate all this dense legal analysis into a few digestible points. So the crucial point is summarized perfectly right here in these 4 takeaways. Number 1, remember the core distinction. The creamy layer fully applies to OBCs right now, but for SCs and STs, it is currently limited strictly to promotion quotas. Number 2, the 2024 State of Punjab v. Davinder Singh judgment is a total game changer because it allows states to create sub-classifications within SC/ST lists, provided they have the empirical data to back it up. Number 3, please do not confuse subclassification with the creamy layer. While the judges observed that the creamy layer could be applied generally to SCs and STs, the 2024 ruling absolutely did not legally mandate it. And number 4, the tension between perfectly targeting benefits and acknowledging continuing social stigma means the debate over substantive equality is far, far from over. I want to leave you with this really provocative question to ponder as we wrap up. As India continues to evolve and grow, how exactly do we craft public policy that perfectly balances the reality of economic advancement with the undeniable need to overcome centuries of historical social disadvantage? The 2024 Supreme Court ruling absolutely opens the door to new ways of distributing justice, but the larger, heavier debate remains in the hands of future legislation and constitutional interpretation. Thank you so much for joining me to unpack this complex topic today. If you found this structured breakdown helpful, keep seeking out clear, objective analysis, and I will see you in our next explainer.